Foundations are general durable power of attorney, healthcare power of attorney, living will, and will.
That's right.
What is a general durable power of attorney?
So a general durable power of attorney is a document that allows you to name somebody to act on your behalf as if they were you for legal and financial purposes. So imagine, Greg, if something were to happen, God forbid you were to become incompetent, incapacitated, unable to act on your own behalf, the question is, what happens next, right? That's where you're the most vulnerable. If you think about protection, what we try to do as estate planning elder law attorneys, we want to protect you when you're your most vulnerable. You're most vulnerable if you have no ability to act on your own behalf because of incompetency or incapacity. So you need somebody appointed legally to be able to act on your behalf as if they were you to make these very important legal and financial decisions like qualifying for benefits to pay for long-term care, setting up protection for assets, and ensuring that your wishes are carried out.
Would my assets be frozen if I became incompetent or incapacitated because of accident, illness, or injury if I hadn't, say, given my wife or my child an agency under a general durable power of attorney to be able to act for me for financial and legal purposes?
Certainly, it can be, it can result in freezing of assets, and it's important to talk about what assets can be just locked up, because a lot of people think, hey, I'm married. I don't need a power of attorney. I have a spouse, they can act on my behalf. But if you have an individual retirement account, keyword being individual, no one else can access that account on your behalf. They can't, get money out of that account to pay for care. They can't utilize that account and protect it. Real property is the same thing. If you're married in North Carolina, even if the property is in just one spouse's name, the other one has marital interest in that property, cannot transfer or otherwise protect that property without that person's signature. If they're incompetent and incapacitated, they can't sign. You got to have a power of attorney.
So what if I become incompetent or incapacitated? I haven't done a general durable power of attorney, the first foundational document. What is the option that my wife, my children, what can they do to access my assets and to pay for my care?
Yeah, it's a good question. Unfortunately, they would have to resort to some type of guardianship. So that's a court-initiated proceeding where they have to tell the court, we think this person is incompetent and incapacitated. They cannot act on their own behalf. Therefore, we're asking the court to take the rights away and appoint somebody on their behalf to make decisions for them. And, that's one of those extreme situations that you don't want to be in because, as an attorney, I want to make sure that people retain their rights even if they have diminished capacity and prevent from having those rights taken away where they can choose for themselves. And, the danger in that is that a family member might not be appointed as guardian. You could have a third party, maybe an attorney you don't know, maybe the Department of Health and Human Services, and there's a lot of, risk and unknown there. So you want to avoid that if at all possible.
Sure. So I can be proactive and do a general durable power of attorney and avoid a guardianship where a court would appoint a power of attorney. And I can choose who I want to be my agent and act for me with a general durable power of attorney, but I don't have a choice in the court proceeding. Is that right?
That's right.
Okay.
But unfortunately, if it does happen, if you do have to resort to a guardianship for whatever reason, there is a power of attorney in place. Thankfully, the person named as power of attorney has priority over any other third party to be your guardian and act on your behalf.
So it's a safeguard even if someone brought a guardianship proceeding for me.
That's right.
Okay. That the person I want to act for me is going to act.
That's correct.
That is phenomenal. The second foundational document is a healthcare power of attorney, deceptively named, okay? It actually appoints an agent to handle your healthcare issues, all right? Only when I can't act for myself. It's my choice what happens with my healthcare until I'm not able to make that choice because of incompetency or incapacity, right? And then who do I want to step in as me and make the right healthcare decisions? In an emergency situation, in a long-term care placement situation, whether I need surgery, medication, any decisions. I'm a huge proponent of and fan of putting a HIPAA authorization built in within the healthcare power of attorney.
Right.
Okay? That way they can also pull my medical records to see, what's going on in the medical records, to get a second opinion, to find out why and aspirin costs $500. You know, there could be many reasons why you would want them to do that, but that's also an important component, I think. And then in North Carolina, a healthcare power of attorney, the agent can also be designated to handle burial.
Right.
And you can designate, that's where you really designate. We see attorneys put that in wills traditionally, but the will really isn't probated for, say, 30 days after someone's passed away. I don't think I'd be in good shape for 30 days unless I was on ice. So you really want to contemplate that in the healthcare power of attorney.
Right.
Mental health care. We want to make sure we decide whether we want our healthcare agent to handle mental health care, because that's a separate statute in the state.
Right.
And if you don't include the mental health care portion and reference that statute, then you're left with not being able to really manage the whole person. And especially as we age, you know, Alzheimer's, dementia, it really blurs the line between physical and mental health care. So we want to include all those elements. These things are complex documents, but they allow you to appoint an individual that you want to handle your care. Now, in a general durable power of attorney for financial and legal matters, or a healthcare power of attorney for healthcare and, you know, any kind of healthcare issue, would it be smart for me to have a successor, somebody waiting in the wings in case the primary agent I appointed could not perform that duty?
Yeah, absolutely. You know, just like any sports team needs to have, you know, a deep bench. You know, you need to have backups. Thing is, though, it's not a popularity contest. You want to pick somebody, especially if you're naming them to control finances, legal rights, that's sophisticated enough to make those decisions on your behalf. If they can't balance their own checkbook, they shouldn't be making your decisions. They should also be sophisticated enough and know your wishes, right? And be, you know, have the wherewithal to ask maybe a professional, even if you're not able to communicate,
Sure.
to ascertain what the decision that would be in your best interest is. Now, you know, one thing that I see a lot, questions that I see a lot from clients asking about healthcare power of attorney is, you know, day to day, I can see a need for that day to day. You know, taking my loved one to the doctor, maybe picking up prescriptions, but, you know, what's the big picture reason for a healthcare power of attorney? Can it help someone, you know, obtain benefits to pay for long-term care? Is it necessary to have a healthcare power of attorney if a loved one's trying to get someone something like Medicaid, VA, to pay for long-term care?
Yeah, so, you know, you will get stopped really at the gate at the beginning if you do not have in place a general durable power of attorney and healthcare power of attorney when you're going to apply for benefits.
Right.
And then we have to shift to guardianship, and which is much more costly. It's a lengthier process. It's a court process. If family members don't agree, many times the default is, again, like you said, to appoint a third party.
Right.
So you might end up with a guardian that you don't want and court oversight over every dollar that's spent. So, you know, should we really trust the person that we're appointing as the agent under a general durable power of attorney or healthcare power of attorney?
Certainly. You know, one of the things that we do as estate planning and elder law attorneys is whenever we're setting up an estate plan, we're ensuring that there are, you know, fail-safes in place, meaning that if you put someone in a trusted position, what we, you know, call a fiduciary position, that's a legal term for it, you want to make sure that, you know, if they were to violate their duty under the power of attorney, that they could be, you know, held liable for that. There's some recourse there. But that doesn't mean that you shouldn't pick somebody that you trust unequivocally, someone that you know can do the job, someone that you know has your best interest at heart.
Absolutely.
That's very important.
Absolutely. So what about a living will? Now, I get confused because there's the last will and testament and there's the living will. What is a living will?
Sure. So living will is your declaration for your desire to die a natural death. So you're saying, look, if I'm terminal, I'm, you know, incurable, I'm past the point of no return, it's okay to go ahead and let me go because I don't want to live in some type of, you know, persistent vegetative state. And this is an important note, a lot of people get this mixed up with a DNR. A DNR is very different. An attorney doesn't draft a do not resuscitate. That's a medical classification that you request, you know, from a medical facility saying, don't take any type of extraordinary means to bring me back to life, to resuscitate me. Whereas a living will is saying, look, do your best, try to bring me back. But if it's confirmed that I'm just, you know, brain dead. Lights are on, but nobody's home. You can go ahead and let me go. Now, why would someone want a living will? Why is this something that someone would request? Personal reasons, number one. Maybe you don't want to imagine yourself languishing in that position. Another thing is, though, that it's important to understand that in North Carolina, spouses inherit medical debt, right? So, and personally inherit.
The doctrine of necessaries.
That's right. They personally inherit medical debt under the doctrine of necessaries, unlike other debt. So if I rack up a bunch of credit card debt in just my name, my spouse is not going to inherit that. But if I, develop some type of debilitating illness and I have to go to the hospital, have to, rack up a bunch of bills, medical bills, she will inherit that.
Right.
So it's important to understand that if you don't have a living will, you could be in a position where, you're not able to express your own wishes, and you could be racking up medical bills because someone has to make the decision. A loved one would have to make that decision. It's a hard decision to make. It takes time to make the decision as to whether or not to take somebody off life support. The longer it takes, the longer, you're racking up that medical debt. So not only do you get to express your wishes, so you absolve somebody else of having to make that really hard decision, you also get to practically avoid unnecessary debt being inherited by your loved ones. Now, with respect to a living will, another important part is, and I'll ask you this, have you ever seen any type of issue with a family where a loved one has had to make that very hard decision, maybe as healthcare power of attorney, and it's caused an issue in the family?
It causes controversy sometimes. I had an aunt who languished for probably 11 years.
Wow.
Because her siblings couldn't agree. And my father was really left to care for my aunt and be the primary decision maker, but everybody couldn't agree. And in that situation, it puts the person that needs either care or might want to be let go in a really tough situation. It put my dad, put the whole family, and they just could not reach a decision, right? So you can clarify that and avoid controversy. I can't think of anything that is a document of greater responsibility, personal responsibility, than deciding if I'm in a terminal, persistent vegetative state, if the only medical procedures that can be done are going to prolong my suffering, me saying it's okay to let me go in that situation, right?
Yeah.
And it can save, my daughters, for example. I think that is a decision that would stick with them to have to unplug dad, right?
Yeah.
I can help them with that decision if I'm ever in that situation.
Yeah, and a lot of folks think they can make that decision, and they probably can, but you really don't want, you would love that guidance.
Sure. Let me ask you this.
Sure.
If I have specific religious concerns that I want certain rituals or religious ceremonies performed prior to being let go, is that something that I would put in a living will?
Absolutely. That's something we routinely do for people with those convictions. We put whatever language is necessary in the living will to make sure that those things are performed prior to, the actual, removing the person from life support.
Sure.
Yeah, absolutely.
Phenomenal. Thank you, Brenton. Appreciate that. So now you've clarified for me the difference between the living will, and now we can go into the last will and testament.
That's right.
Your living will does not pass property or title to assets.
Nope.
Your last will and testament does.
Right.
So the last will and testament appoints an executor, which is the person that is responsible for overseeing the transfer of assets through the probate estate.
That's right.
I've heard people many times say, hey, I have a will, so therefore I don't have to go through probate. That is exactly the opposite, okay?
Right.
And people have that misconception sometimes.
Yeah.
Probate is the process by which a last will and testament passes your assets. It is a court process.
Mm-hmm.
And I would say minimum 6 months.
Yeah.
Okay, or longer, right? We have some probate estates that run much longer. It just depends on the complexity of the estate. Last will and testaments also direct how the money or real estate or vehicles or any asset that has to change title other than a beneficiary asset through probate, it says who's going to get what.
Right.
And what percentages or dollar amounts, right? So it really allows you to control your assets as they flow through the will. But then when we're looking at an estate plan, or when you're considering an estate plan, ask yourself this question: is a last will and testament the right place to pass my assets? Is it the best place? Because in North Carolina, the only place that a claim from a creditor can attach is during the probate process, when the last will and testament is passing your assets.
That's right.
So if there is a danger of a long-term care event, which right now averages, the numbers are all over the place. The highest I've seen recently is $17,000 a month. Okay.
Right. Yeah.
I mean, you think about multiple years of that, and it could spin down even a large estate. So if you're in that situation, a spouse is in that situation, or that might be something that would happen in the near future, and I would ask you, what percentage of people over 65, according to a U.S. Department of Health and Human Services study done in 2005,
Right.
are going to need some type of long-term care, in-home assisted living or nursing home care?
Yeah, so the answer is 70% of individuals who make it past the age of 65.
70%.
Yeah.
That's why this is so important,
Yep.
right? 70%, that's a great, a large chance, right?
Yes.
A more chance than not that someone over 65 right now will need long-term care. And the cost can be exorbitant. Therefore, we want to avoid in certain situations, using the will as a primary place to pass assets. We might want to look at the last will and testament like an insurance policy, right? That if something failed, then we have it there to kick that asset over to a trust or make sure it gets to the right person.
Right, the will should be thought of as a last line of defense.
Right.
The thing that
I
you
agree.
rely
Yeah.
on, that's like a safety net
I like
that
that
ensures.
term.
Yeah.
Last line of defense.
Yeah, and a lot of people think about the will, just like you said, as something that helps you avoid probate. A will is just a guide through the probate process. That's really what a will is.
Sure.
And you do name an executor. It's important to know that if you name an executor, that person's not the executor until they're nominated by the court.
They have to qualify as the executor.
That's right. Yeah. And they have to take an oath and everything and be appointed by the court to be the executor. So if you think about a will, think about probate, think about the probate court, think about the probate court taking jurisdiction over all of the assets and requiring your executor to go through an extensive accounting process to, navigate a complicated legal system, and giving the chance of any creditor who wants to make a claim against your assets to be able to do so within, a 90-day period. And
including healthcare claims or long-term care Medicaid
Sure.
claims, if they've had to come in and pay for nursing home
Oh,
care.
trust me, I hear a lot of folks saying, I don't have any creditors, I pay my bills, why should I worry about creditors? Most people incur debt that could, saddle their estate right before they pass away. So we're talking about the medical debt that you incur right before you pass away, whether that's hospital debt, likely long-term care debt, though, whether it's in-home assisted living or skilled nursing care.
And what about being under the contempt power of the court?
Yeah, if you're an executor,
if you're late
Right.
moving an asset around, or you're dealing with a stock company, or some entity that's not responding, right?
Yeah. Let's say I'm an executor. I'm probating an estate. Someone named me the executor. I was appointed by the court, and I'm trying to do my best. It's complicated. The will is a legal document. Maybe I have trouble interpreting it. Maybe I'm having trouble understanding just navigating the process. If I mess up, I can be held in contempt by the court. They can put me in jail for messing up.
That's right. That's the seriousness of the probate process.
Right, even if I'm the only heir too, by the way.
Yeah. That's tough. It's tough. That's a great summary of foundational work. General durable power of attorney, healthcare power of attorney, living wills, and wills. I would like to offer a free consult to sit down with an attorney and review your estate plan and talk about what tools in estate planning would be right for you. You can take advantage of that free consult by going to mcelderlaw.com. That's M as in Mike, C as in Charlie, elderlaw.com, or calling 1-888-999-6600. And thank you so much for joining us today.